this video, we'll be discussing evidence as part of our MEE Highly Tested Issues Guide. In order to do well on an evidence question, you first have to be aware of how it's tested. Evidence is regularly tested on the MEE, and it's specifically tested on average about once a year. It is generally tested on its own and not combined with another subject. However, in the past, when it has been combined with another subject, it was combined with criminal procedure. And those questions tested a Miranda and hearsay issue. We understand that oftentimes evidence and the way they test it can be predictable, but it's nonetheless a very challenging subject to learn. Evidence is a subject that has its own learning curve when it comes to application. Many examinees can memorize, but then they struggle with the rule application. This is why you want to make sure that you're setting aside time to become familiar with those highly tested issues and then practicing those issues. So let's turn to some of those highly tested issues. The first highly tested issue that we have to discuss is hearsay. Hearsay is the most highly tested topic on evidence MEE questions. If you see hearsay tested, be sure to introduce it properly before jumping into an analysis of exclusions and exceptions. This is one of the biggest mistakes that we see examinees make. Remember to connect the dots for the grader and don't make any assumptions without spelling them out. So start your hearsay essay off by defining it. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Then go on to tell the grader why it's important to determine if a statement is hearsay. Explain that when a statement is hearsay, it's generally inadmissible unless there's an exclusion or an exception. This sets the tone that you're credible and you know exactly what you're talking about. Then, if you conclude that a statement is hearsay, you can go on to define the applicable exception before analyzing it. Before we talk about some of those exceptions, there's one thing I want to note. In the past, when hearsay's been tested, if a statement can fall within multiple hearsay exceptions, the examiners discuss all of those possible exceptions. I point this out because some examinees will stop evaluating the exceptions once they find one that applies. But when they do this, they lose out on points if there were other applicable exceptions that they failed to discuss. So for example, oftentimes a statement can be a present sense impression and an excited utterance. So if a statement could be admissible as both, talk about both. This way you're getting as many points as possible. So let's talk about some of those favored hearsay exceptions. The first is an excited utterance. So this is a statement relating to a startling event or a condition made while the declarant was under the stress of excitement that caused it. Present sense impression. This is a statement describing or explaining an event or a condition made while or immediately after the declarant perceived it. Statements made for the purpose of medical treatment or diagnosis is a statement made for and must be reasonably pertinent to a medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, and their inception or their general cause. Business records are a record of acts, events, conditions, opinions, or diagnosis, and these are admissible if they're made at or near the time of an event recorded by a person with knowledge of that event. The making of the record must occur in the course of regularly conducted business, and it must be in the regular practice of that business to make such a record. So when it comes to hearsay, we recommend that you make 3 lists. One that contains the hearsay exclusions, or non-hearsay. The second that contains the hearsay exceptions that require the declarant to be unavailable. And the third to contain the hearsay exceptions where the declarant can be available or unavailable. We then recommend that you state each of those rules elements and then memorize them. This way you can work on keeping exclusions and exceptions straight and then apply them properly when they're tested. The next heavily tested topic is impeachment. There are 7 ways to impeach a witness, and we recommend that you memorize them. In fact, I recommend that you make a list of the 7 impeachment mechanisms, how they operate, and whether or not extrinsic evidence can come in. This way you'll have your bases covered when it comes to this issue. And it's also going to help you master it for the MBE. It's also key to remember why this evidence is being admitted, to show the jury not to believe the witness. So let's turn to those impeachment mechanisms. prior inconsistent statement. Under this mechanism, any prior inconsistent statement can be admitted to show that the jury should not believe the witness because the witness said something inconsistent in the past. These statements come in to impeach and sometimes can be used as substantive evidence if it falls into a hearsay exclusion or exception. Generally, the witness must be given some sort of opportunity to explain or deny those statements, but there are exceptions. Next is impeachment by bias. Evidence of bias can be used to show that the jury should not believe the witness because they're biased. For example, if a witness is testifying in favor of their mother, they have a very clear bias. Other examples of bias and interest include things like family members, friends, an enemy, paid by a party, and if someone's been granted immunity. Impeachment by conviction of a crime. If a witness is convicted of a crime that meets certain requirements, then that crime can be admitted to show that the jury shouldn't believe this witness because the witness doesn't take the law seriously. The law states that convictions of any crime, misdemeanors and felonies alike, where prosecution is required to prove an act of dishonesty or false statement, is automatically admissible, subject to the 10-year rule. For instance, income tax fraud, embezzlement, and perjury all qualify. Prior bad acts are admissible for impeachment purposes. However, these must relate to truthfulness. Remember, the purpose of impeachment is to show the jury that they shouldn't believe the witness. So bringing in prior bad acts that illustrate untruthfulness furthers that goal. The way this works is that during cross-examination, a party might inquire into specific acts of misconduct if they're probative of truthfulness or untruthfulness. However, extrinsic evidence is not admissible. Reputation or opinion for untruthfulness. If a witness has a reputation for being untruthful, or if in someone's opinion that witness is untruthful, this can be used to show the jury that they shouldn't believe the witness. This is done by a party calling a witness to the stand to testify in the form of an opinion or to explain someone's reputation. Impeachment by sensory deficiencies is when the witness's testimony regarding their perception or their memory is questioned due to their ability to remember or to perceive. For example, if a witness is testifying about something that they saw and they can't see, then this could be used to impeach the witness. Impeachment by contradiction is when the witness makes a mistake in their testimony or lied. Then the witness can be contradicted. This is done on cross-examination. The opposing party can question then about what was said. Now, the final highly tested issue that I want to discuss in detail is the Sixth Amendment Confrontation Clause. Pursuant to the Sixth Amendment, criminal defendants have a right to confront their accusers. So, a statement is generally not admissible in a criminal case if that statement is testimonial, the declarant is unavailable, and the defendant did not have an opportunity to cross-examine the witness. This is key to remember on an evidence MEE because sometimes a statement may fall into a hearsay exclusion or an exception, but it violates the Confrontation Clause, and thus it shouldn't be admitted. So be sure to keep this concept in mind. Now, other issues that have come up on evidence MEE questions are things like character evidence, relevancy, policy exclusions, and witness testimony. These are worth knowing well, and they're going to help your performance on not only the MEEs, but the MBE questions as well. Our next tip for doing well on evidence MEE questions is to make a visual map of why evidence is being offered. The concept in this tip was briefly touched upon when we discussed impeachment. But to explain it in greater detail, when you review evidence, get in the habit of asking yourself, why is this evidence being admitted? This is helpful because there's a lot of overlap between things like hearsay and impeachment and character evidence. So if you can get to the bottom of why a piece of evidence is being offered, you'll be able to apply the correct rule. So to give you some specific guidance, if evidence is being offered to prove that a statement was said, there is no hearsay issue. So consider a non-hearsay purpose for offering the statement. If evidence is being offered to prove that a statement is true, there is a hearsay issue. If evidence is being offered to show the jury that they shouldn't believe a witness, then there's an impeachment issue. If evidence is being offered to show a witness's good or bad character, then you have a character evidence issue. Or if evidence is being offered for another purpose, like motive or intent, then you have a mimic issue. Our fourth tip is to learn the basic definitions to introduce each set of rules. I won't go over every single one that's in our guide, but for example, remember with hearsay, I told you to always start off that issue by defining hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Another rule that examiners love to see defined is relevancy. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And the fact is of consequence in determining the action. Again, these are just some examples, but they serve as a nice reminder to slow down and to define those key terms for the grader before you jump into your analysis of an issue. Our final tip is to practice. As I mentioned earlier in the video, evidence is tricky. Many people can memorize it, but they really struggle in their application of it. So be sure that you're setting aside time to practice a variety of MEE questions. That wraps up our discussion of evidence as part of our MEE Highly Tested Issues Guide.